Hello, friends. Welcome to Investment Immigration Conversations. I'm your host, Carolyn Lee, principal and founder of Carolyn Lee PLLC, a U.S. immigration law firm dedicated to helping clients build their futures with investment immigration. Happy Mid-Autumn Festival. So today's event is all about entrepreneurs and an immigration pathway allowing them to remain in the United States, work on and develop their high growth startups. So we're going to be talking about the International Entrepreneur Parole program, revived, rebooted, accepting applications right now, and also the LIKE Act, which is a bill, not yet law, introduced by Representative Zoe Lofgren, a longtime friend to entrepreneurs and startups. So I'll be touching on the LIKE Act toward the end. By way of background, a few years ago, I was invited to participate at an SBA workshop, Small Business Administration workshop, where a university official expressed to me great frustration at the inability for her to keep or to advise talented foreign national entrepreneurs with great ideas to stay in the United States. There were really no viable immigration options to do so. Why is that? Because one, the traditional H-1B route is really not suitable. It's about an employer-employee relationship with a company, and they don't want to work for another company. They want to work on developing their own startups. Two, and yet self-petitioning on an H-1B basis for their own companies, not really a viable option, never really has been. Three, they often don't have enough capital yet to make a substantial investment in their own startups to qualify for an e-visa. And four, they're not yet there in terms of their careers to petition for any self-petition for extraordinary ability. They'll eventually get there, but not yet. So they're packing up their incredible ideas and all their talent and leaving our shores and going back home. We don't want that. We want those talented entrepreneurs to stay in the United States. Folks like Sergey Brin, the list goes on, Hamdi Ulukaya, Elon Musk, Arianna Huffington. We want these folks to stay in the United States, develop their talent, grow our economy, and keep America the beacon for entrepreneurs to realize their dreams. So with that hopefully rousing introduction, let's kick things off. Normally, I don't like to use a PowerPoint or a presentation, but in this instance, I will, because it's actually quite technical, what we're talking about, the International Entrepreneur Program. So I must do this, my apologies. I have to start with a disclaimer. This isn't immigration legal advice, and this doesn't create an attorney-client relationship either. So let's talk about IER. Requirements. There are requirements for the entrepreneur, him or herself, and there are requirements for the startup entity. So the requirements for the individual entrepreneur, him or herself, are they have to have substantial participation in the startup entity, which means that they have to have at least a 10% ownership interest. And there can be up to 3 entrepreneurs per startup entity, each owning at least 10%. The entrepreneur has to have a central and active role in the startup entity. It can't be passive. And if granted, the initial stay is good for 30 months. And if they qualify for re-parole, the parole can be renewed for an additional 30 months for work authorization solely with the startup entity. In terms of the startup entity requirements, the U.S. entity, the entity has to be a U.S. entity, and it has to have been formed recently, which means within the 5 years preceding the application. And within the 18 months preceding the application, it has to have received funding, an investment of at least $264,147. It is actually still currently $250,000, but it's been adjusted according to CPI, and it will go up to the 264K amount as of October 1, the start of the next fiscal year. And this amount has to have been received from a qualified U.S. investor, which I've highlighted because I'm going to go into the qualified investor requirements as well. It's very important. Alternatively, the entity could have received, again, within 18 months preceding the application, a U.S. government award or grant of at least $105,659 previously, or I should say still currently, $100K. And it's a U.S. government, includes the federal government, state, and local. Now, if an entrepreneur startup entity does not meet these requirements to the dollar, all is not lost. Partial satisfaction can still qualify if there's other reliable and compelling evidence of substantial positioning to grow and to create jobs. In terms of the process, it's got to be about making the case that there is public benefit to be served. And the evidence has to all drive toward that public benefit in this specific way. It's discretionary, so we don't want to take this discretion for benefit, although the very objective criteria are helpful in organizing the evidence. The application is made on the Form I-941 with fee and biometrics fee. It's roughly about $1,300 currently total. Dependents can concurrently file or after the grant of parole on the Form I-131, also with a biometrics fee. The approval is not a grant of parole. The entrepreneur has to, if outside the United States, obtain a travel document or boarding foil from a U.S. consulate and then be admitted or paroled. It's not a change of status if they are already in the United States in another status. The entrepreneur can be an employer or it can be an employee. And if an employee must be I-9'd like other employees. So this is where I want to talk a little bit more about the U.S. qualified investor requirements, because it's important, and the form goes into the qualified investor in some detail, the Form 941. The investor has to be a U.S. citizen or a green card holding individual, if an individual. If it's an organization, it has to be majority owned by U.S. citizens or U.S. citizen and or permanent residents. In addition, in the preceding 5 years before the entrepreneur's application, that investor, entity, or individual must have participated in investing substantially, defined as $633,952 as of October 1, currently $500,000 in startup ventures, in other startup ventures. And 2 of those startup ventures have to have either created 5 qualified jobs. The criteria for qualified jobs are quite similar to those applicable in the EB-5 context. They have to be US workers essentially, and for full-time employment. And or the startup could have generated $528,293, currently $500,000 in revenue with 20% annualized growth. So the investor has to be in the business of or have had significant experience, successful experience, investing in other startups that have grown as a result of their investment in part. So those are roughly the requirements and the process. So I'm going to quickly touch on the LIKE Act, which is very similar. The LIKE Act would actually create a status, would be a visa classification. So by way of distinction, the parole, International Entrepreneur Parole, does not grant status. It's granting parole or permission to be in the United States and work authorization as well, but it isn't non-immigrant status. So the LIKE Act would confer W status, this would be new, based on issuance of W visas for entrepreneurs, employees, and their derivatives. The criteria, very, very similar to the IEP, very similar. The visa would allow for self-petitioning. So this is the problem with the H's requiring employer sponsorship. The entrepreneur could self-petition for 3 years, and that would be extendable for 3 additional years and additional increments of 1 plus 1 additional year to meet the parole requirements. Dual intent is also permitted, which means that the entrepreneur could be in W status and also be pursuing immigrant status or a green card, and it would be perfectly compatible. Again, by way of contrast, some non-immigrant classifications like the F1 visa status or B1, B2 visitor status do not permit dual intent. So one could not pursue lawful permanent residence or green card and be in those non-immigrant statuses. Moreover, the LIKE Act would provide a green card path for lawful permanent residence, and the process would be self-petitioning, no outside or third-party sponsorship required. No numerical limits. So our entire visa system on the immigrant side, on the green card side, is based on numerical limits and quotas, except with respect to immediate relatives. So there are no numerical limits with respect to the W visa holders, as many as would apply and qualify. They have to have maintained W status or another status that's the basis of employment with the startup entity. So the startup entity remains central in the green card process as well. The startup entity has to have created 10 jobs, and in its lifetime, it has to have raised 1.25 million in qualifying investments or generated at least $1 million in revenue in the 2 years preceding the green card filing. So very interesting law. This is the kind of bill that's written when we believe that we can use our immigration system to enhance our economy and to attract talent. So this is a fantastic bill, and we're all hoping that it eventually gets enacted into law. So that is our quick primer on the IER. So at this point, I'm going to open the floor for questions. Oh dear, there was no PowerPoint. Oh no. Well, hopefully, thank you. You can only see me. Oh, bummer. Luckily, I tried to look my best today. You can't see the PowerPoint either. Bummer. Okay. Well, in the interest of time, I will not launch the power. Oh, what the hey. We're clipping through. Let me just do it real quick. All right, here we are. You would think I'm a Zoomer neophyte. Okay, here we go. So I'm not going to, well, this is a bit tricky because I don't want to repeat the content, especially since this will be posted, folks. And I did go bullet by bullet, so I think we're okay. Yeah, so these are the investor requirements. These are the entity requirements for the startup. This slide is about the presentations. I mean, is about the process rather. This slide is about the qualifying investor requirements. And this slide is about the LIKE Act. which is super cool. And we want it to become law. Okay, there we go. Sorry about that. I really did intend, thank you. I really did intend for this to be a short primer on this quite exciting development that fills a lacuna in our investment immigration landscape. What about those entrepreneurs who don't have $500,000 plus to invest into their entities? And really, where the job creation, while greatly desired and is aspired to, may not be a part of the business plan. And I think we're seeing more of that in our economy and with new businesses. They can do fantastic things with a machine and a camera and may not need to staff up. So this is the solution for those entrepreneurs. But they do have to show that it's been underwritten. And the underwriting has to be by folks who are experienced in identifying the startups and who have a track record of success funding those startups. So it isn't for every single startup. It's for startups and entrepreneurs poised for high growth that have already proven their merit in some way in the market of acquiring capital. So yet it's still something. It would address some of the talent that university official was talking to me about at the SBA conference many years ago. So this is a positive development. Not seeing any additional questions. I'm going to let everybody have the rest of their hour back, if that's what you've allotted for this presentation. And we will keep talking about this. We will definitely keep talking about this, so please stay tuned. Have a good afternoon, everybody.